So you have two different parts. One where typically most people get a bondsman, and the bondsman pay 10% of their bail. So if your bond is $1,000, the bondsman will pay $100. $100 to a person that doesn't have any funds, or doesn't already struggle with their bills, that $100 is hard to come across. That's why the Hampton County Community Bail Fund was created. It's a lump sum of money that was put in a pot, bail out those that cannot be able to afford to bail themselves out. So we bail people out up to $5,000, as long as it's not any violent crimes, as far as domestic or anything like that. You don't have any warrants, anything. You actually basically can qualify for the Hampton County Community Bail Fund. People that don't need to be sitting in jail because of lack of funds. That's what I would say. Because you're innocent until proven guilty. And that's where we play a big part, because a lot of our people that goes to court, a lot of it is thrown out. So they was put in an unfortunate situation. And of course, that situation with them already not having, it plays a major part into them not getting out. So we come in and we help them out as a community. Welcome, everyone. Welcome. I'm Mr. Alan Swapshire. I'm the co-chair for the Criminal Justice Task Force and also a community organizer for Caleb. Thank you all for joining us tonight, part of our Justice series. Tonight, this is one event of our Justices. This is the first. Tonight, we have two amazing people coming to the table to be able to give us their expertise, and we're going to be diving directly into about the prosecutor and the power and the different things that they're capable of doing here locally and all around. So thank you all for joining us, and we'll get started.
We think that criminals go to trial and they face a jury of their peers, and there's some deep deliberations and soul searching, and a judgment is rendered.
That's not the reality of how the system works. Of those cases that end up resulting in the guilty verdict, about 95% of them come out with what we call a plea bargain. No trial, no judge, no jury.
Take our plea and you might get 2 years, 3 years, 5 years in prison, or risk it and go to trial, in which you could get found not guilty and walk free, or you could face what's called a trial penalty, 10 years, 20 years in prison.
To understand the power that prosecutors wield, you got to try to put yourself in the shoes of that person. So you combine the force of being locked up and being homesick and wanting to go home, the fear of what you're missing on the outside, the risk of going to trial. And it's this perfect equation, this perfect combination of forces that make even people who are innocent plead guilty.
So judges and prosecutors rely on plea bargains to keep the system moving. If everyone who had a defense took their case to trial, the system would collapse.
Plea deals are quick, they're easy, they happen in a flash, but the consequences are lifetime.
Good evening, everyone. My name is Mike Fulbright, and I have the privilege and the opportunity to serve on the Caleb Criminal Justice Task Force, and have been with that group for the past year and a half or so. And I appreciate the opportunity to do that, and appreciate the opportunity to take a few moments this evening and to share just a few things with you from a foundational perspective to kind of set the table a little bit for our conversation with our two special guests here that will take place here in just a few moments. The role of the prosecutor is oftentimes a misunderstood role and an underestimated role. Prosecutors determine the baseline of whether or not an individual is charged, the nature of the crime, the length of the sentence, They can have a heavy say in whether or not a juvenile is charged as a child or as an adult, and many other key factors affecting the outcomes of trials of those involved. It's appropriate that as we reflect this evening on the role of the prosecutor, that we also reference for just a moment, reflect further on the idea of mass incarceration in the United States. Prosecutors' offices have historically played a major role in our country's dramatic reliance on jails and prisons. Mass incarceration, by definition, refers to the fact that the United States is by far the leading country in terms of incarceration and prison population. The number of people incarcerated in the United States has multiplied 5 times over since the 1980s to a total of almost 2.2 million people. And this dramatic rise has continued independent of crime either rising or falling, which is very, very interesting. But as we know, mass incarceration doesn't affect all communities equally. About 60% of the population of incarcerated people in America are either Black or Hispanic. 1 in 3 Black men will experience time in prison in his lifetime. 1 in 6 Hispanic men will experience time in prison during their lifetime. This issue is especially important in Tennessee, where the number of incarcerated people per capita is well above the national average. We see the same dynamics, and we also see the same demographic dynamics at play here. 22% of African Americans in Tennessee currently are unable to vote due to previous convictions. That is over 1 in every 5 people. As highlighted in the previous video that we just saw, most people that go through the criminal legal system today waive their right to a trial, and in so doing, waive their right to a host of protections that come along with that trial, including the right to appeal. Instead, they plead guilty. Very few cases go to trial. 97% of the federal criminal convictions are obtained through plea bargains. And when it comes to the states aren't far behind. That percentage is at 94%. Criminal convictions are obtained through plea bargain. This process has become such a basis for court operation that in 2012, Supreme Court Justice Anthony Kennedy acknowledged that plea bargaining is, quote unquote, not some adjunct to the criminal justice system. It is the criminal justice system. Because of plea bargains, the system can quickly handle the criminal cases of millions of Americans each year involving crimes or from anything that would be fairly petty in nature to very serious crimes. But plea bargains make it easy or easier for prosecutors to convict defendants who may not be guilty, who don't present a danger to society, or whose crime may primarily be a matter of suffering from something such as poverty or mental illness or addiction. Thanks in part to plea bargains, millions of Americans now have a criminal record. In 2011, the National Employment Law Project estimated that figure to be at 65 million Americans with a criminal record. And it is a mark that can carry with it significant consequences for things like education and employment and housing. Having a record, even for a fairly trivial offense, means that a person may very well face tougher consequences or more serious punishment if he or she has to encounter the legal system again. Along these lines, it's also appropriate for us to touch for just a moment on the elected terms of district attorneys in the state of Tennessee. District attorneys in Tennessee serve the longest terms for elected prosecutors in the nation, which is very interesting. 8 years. And this lengthy term was set as far back as our state's constitution in 1870. Once in office, interestingly enough, many of these district attorneys serve for decades. Hamilton County, our home county here, serves as a perfect example of this. We have had 4 individuals serve as district attorney general in Hamilton County since 1958. And that is a remarkable, level of influence in the hands of a very, very few people when it comes to our criminal legal system and how it operates. 4 district attorney generals in the last 64 years. In spite of the importance of this elected role in our county and other county offices, local elections often suffer and lag far behind voting participation when it comes to a comparison to those who participate in the much more publicized national elections. The last time our community had the opportunity to vote for a district attorney general was in the year 2014. And out of over 206,000 registered voters, less than 16% of those individuals chose to cast a vote. This issue has become important to me because as a person, as a resident and a community member of Hamilton County, there are certain core values that are very near and dear to my heart, and justice and fairness and equality and individuals being treated with compassion and fairness lies very, very close to my heart. And so it has been an honor and continues to be an honor for me to serve with this particular task force and to come alongside and to participate in this particular cause. Because it hits home for me, because I believe that the health of our communities and the health of the systems and substructures that make up our communities are hugely important to the state of our health in Tennessee and in our nation at large. I'll just close with this. In the weeks and months that will serve as the run-up to our election in the month of August, our community will get to hear from numerous candidates who are seeking the position of District Attorney General, as well as from the incumbent District Attorney General himself. And this is an opportunity for those of us in the community who care about our communities and our neighborhoods and the people that we live and do life with. This gives us an opportunity to speak out on the values that we would most like to see reflected in this particular office. But it's also a time for us to better acquaint ourselves and to educate ourselves on how these systems work and how they affect our friends and our families, our neighbors, our neighborhoods, and our communities. And to help us do that tonight, we are joined by 2 guests with unique insight into the role of prosecutors. And at this point, I want to pass the baton to my friend and colleague, the Reverend Troy Brand of the Orchard Park Seventh-day Adventist Church. And so, Troy, at this point, the floor is yours.
Hey, thank you, Mike, and I appreciate that overview. Very insightful and helpful for those who are not, or just not familiar or slightly familiar with the role of a prosecutor. And I think we're going to get a lot more details about what you shared from our 2 presenters. First, we have with us today Lee Davis. He's a criminal defense attorney, a former assistant district attorney. He was the first attorney in the United States to introduce the mitochondrial DNA evidence. So he's a trendsetter and a trailblazer. He's tried over 200 jury trials to verdict, including lead counsel in 6 death penalty cases. So he's not a novice. He's a man of experience. Lee has argued cases before the Tennessee Supreme Court, the Court of Criminal Appeals, and the Sixth Circuit Court of Appeals on the federal level. He is admitted to practice before the United States Supreme Court as well. Mr. Davis was an assistant district attorney in Chattanooga, where he prosecuted serious felony cases including cold case homicide investigations and more than 20 first-degree murder jury trials. He's also served as a special prosecutor and a special judge in criminal proceedings in Tennessee. Mr. Davis, I guess, can I call you Lee? Welcome and thank you for joining us today.
Thank you, Troy. I enjoy being with you this evening. Thank you for asking me to join the panel discussion. I look forward to it.
All right, right. Give us a little bit more about yourself before we introduce our next guest.
Sure. Yeah, I've been in Chattanooga since 1991. I'm a Yankee moved south. I was happily practicing criminal law up in Boston, Massachusetts when I met my wife, who's a local school teacher. And when I moved here, that's when I became a prosecutor. Since I was not familiar with the area, I thought and actually I met an attorney who was in the DA's office. So I thought that'd be a good way to understand the criminal justice system. And so I was a prosecutor here for 5 years and prosecuted thousands of cases from low-level misdemeanors to the most serious cases, murder cases, death penalty cases, those kinds of things. Awesome. I've had my private practice for 25 years over in the Fort Wood section of Chattanooga, and we represent people in state and federal court, everything from small misdemeanors, again, all the way up to death penalty cases. My most recent jury trial was a murder case that we won last week in Bradley County, and we handle cases throughout the region. I've tried cases in 18 different states and one case in Spain earlier in my career. So I think I'm well versed in these issues. I understand the role of the prosecutor. I also understand the potential problems that prosecutors can sometimes have, especially with the issues of mass incarceration. One thing I would point out, though, is that in every case, one of the first determinations you need to make is it a victimless crime or is it a crime that involves a victim? Because the same neighborhoods that are plagued with mass incarceration are also plagued with violent crime. And anytime that there is a case where there's a victim, those victims need to be watched out for and protected. And that's one of the most important roles that a prosecutor has. When it's a victimless crime, when it's crimes of basically where you're prosecuting poverty or you're prosecuting drugs, you're prosecuting things where someone is hurting themselves as opposed to somebody else. Those are the ones that definitely need to be looked at more closely. We are not, as a society, we really are not doing anything any differently now than we were in the 18th century in terms of how we dispense justice. We incarcerate people, and we've changed everything else about our world except how we handle our criminal justice. And so I think fundamentally as a system, I think you could get a lot of prosecutors and defense attorneys to agree that, especially on crimes that involve mass incarceration from the point of view of poverty, those need to be separated out from the violent crimes. And I think that the legislature in Tennessee, as well as other states, has not kept up with those types of advances in thinking across the country. So that's probably a good place to start. But that's probably enough of an introduction for me right now.
Yeah, hey, listen, I was sitting here thinking, I'm like, man, this guy is loaded. You just came out with guns blazing right away. We really appreciate that foundation you laid. But we have another guest, and we're going to have both of you guys kind of carry us through this whole concept of a prosecutor. But let me introduce our next guest. Our other guest we have with us is Miss Jessica Van Dyke. She is the executive director with the Tennessee Innocence Project. She's a graduate of University of Tennessee Law School, where as a law student, she cut her teeth on post-conviction work in university's wrongful convictions clinic. She has remained passionate about wrongful convictions, and after 8 years at Parker Lawrence, Cantrell, and Smith, she left the firm in 2019 to help launch the Tennessee Innocence Project. Jessica is a proud graduate of Knox College in Galesburg, Illinois, and received a master's degree from Vanderbilt University. She served on the Tennessee Association of Criminal Defense Lawyers Board of Directors and served for several years as the organization's Indigent Defense Chair. She has been the recipient of the TACDL's Workhouse Award and the Robert W. Ritchie Service Award. She's a member of the Nashville Bar Association, the Tennessee Bar Association, and the National Association of Criminal Defense lawyers. Miss Van Dyke, if I can call you Jessica, I would appreciate it. Welcome and thank you for joining us.
Please, yes, please call me Jessica, and thank you. It's great to be here with y'all tonight and with Lee, who has so much incredible experience on both sides of the courtroom. And I live here in Nashville. We cover the entire state, so we have cases from East Tennessee to West Tennessee. So my experience, I think, as we kind of go through this program tonight, we talk about the role of the prosecutor. What you'll find is that I'm talking about correcting errors on the back end. And so I frequently say, if people don't get it right on the front end, then they're going to reach out to us. Just a big picture introduction, that different studies estimate the number of wrongful convictions to be between 1% and 6%. Some studies estimate as high as 10%. But Mike gave such a wonderful introduction when he showed those statistics about mass incarceration. And so, I think, and I haven't looked at them recently, but TDOC reports their statistics for the Tennessee Department of Corrections, as at any given time, you'll have approximately 30,000 Tennesseans serving some sort of a sentence through TDOC, whether it's incarcerated in a prison or community corrections. So if you think about 1% to 6% of those individuals, let's say it's just 1%. Let's just say it's 10 people that are in prison wrongfully convicted. We believe as a society that that's unacceptable and we need to fix that. So a lot of what we're going to be talking about tonight, I think the pitch is that if someone in the system, whether it's a prosecutor, a judge, or a defense attorney, doesn't get it right, we're going to see those at the Tennessee Innocence Project. We're going to have to try to really at that point move a mountain, because it is nearly impossible to overturn a conviction. And so, as we kind of talk about this, we're going to hear how all of these parties play an important role. But the reality is the prosecutor early on has the ability to make really crucial decisions about who is charged, how they're charged, and what happens next.
Right. Awesome. Okay, thank you very much. So let's just get straight to it. Since forever, but in recent times, 2014, 2015, 2020, and times in between, we've had these high-profile cases of Black men in particular being killed by police officers. And we have this public outcry against the police department. And we're fearful of these judges who may sway the decisions or so forth and so on. And we know or we believe as a community that police are the enemy, or they're dangerous and they're crooked or whatever. And then judges, they're dangerous and they're crooked or something to that effect. But I need you guys to help me out. How does the prosecutor's office work, or the district attorney's office, that's what it's called in different areas? How does that work? What kind of power does an elected official have? And then at the same time, talk about how that works as it relates to plea deals and so forth. So help us out with that. Help us move the myth away from the police, even though they are dangerous, but help us to move away from the thinking that police officers are the biggest threat in criminal justice.
Jessica, you start. I'll chime in.
Well, I think we watched the bail video earlier, and I think the key question is, what are prosecutors charging and how are they charging people? So if your prosecutor locally determines they're not going to prosecute small amounts of marijuana, then that limits interactions between police and individuals with small amounts of marijuana. So I think, that's a question. How is your prosecutor, the smell of marijuana is in a lot of different warrants to search vehicles or homes or whatever it may be. So asking questions about what is your prosecutor charging? In Nashville, we saw, I think, a pretty big decrease in our jail population in the last 8 years. And in part, that was because we stopped bringing everybody who was driving on a revoked license. I say we, like I'm in the district attorney's office, I'm not. But I do know that was something that was very common, was that we were charging people with driver's license violations, which, having a license, I think, goes back to what Lee was talking about. Does having a driver's license mean that you are a danger to someone else? Not inherently. I mean, if you're a bad driver, you could have a license or not have a license. But, you know, having a license oftentimes for many people comes down to their ability to pay court costs and court fines. And if they can then, you know, get their license back, it's been suspended. So, you know, even at the most basic level, what is the district attorney's office doing about crimes like, you know, smaller amounts of marijuana for personal use? How do they handle driver's license cases? Those are questions of, you know, right from the beginning that people are going to be looking at. And then if someone is charged, how is their bail? What is that amount? How is it set? And is there a pretrial release program within the local county that allows people to even make a pretrial release without any sort of a bail whatsoever if they qualify?
Right. So excuse me real quick, Lee. So what you're telling us is police officers make arrests based on what the prosecutor is going to charge. Is that a simple way of saying that?
You know, I think that's one way of looking at it. I can't say across the board that's what happens, but, you know, I think police officers could certainly arrest anyone who violates the law, and the law is what the law is. I think once someone is arrested or cited, how they are dealt with thereafter often becomes the decision of the prosecutor.
Okay, thank you.
And I can give sort of a local flavor of how that happens here. So here in Chattanooga, Hamilton County, let's say there's an arrest on a Friday or Saturday night. Police make they pull over a car, tinted windows. They say they smell marijuana. They get the people out and they arrest them for either a small amount of marijuana or odor of alcohol in the DUI. So it's a standard arrest. Those individuals will either make bond or not make bond over the weekend, and they'll go to Hamilton County General Sessions Court Monday or Tuesday morning. And this is where one of the fundamental problems occurs. In General Sessions Court, you have, that's where the assistant district attorneys are. So you have the elected DA who serves the 8-year term that we talked about. And then you have assistant district attorneys that are assigned to one of the 3 General Sessions divisions on the 2nd floor of the courthouse. And every week, the same thing happens. People who are arrested over the weekend come into court. People in custody go to courtroom 4, courtroom 3. People not in custody go to one of the other courtrooms. And then prosecutors are trying to sort out who do they keep in custody, who do they make an initial plea offer to. Maybe there was something involving violence, so they want to have a preliminary hearing later. And what do they have to do? They have to assess credibility very quickly. The same police officers who made the arrests are there. Those police officers, the district attorneys see week in and week out. So if it's, let's say it's one of these situations where a car gets pulled over for the smell of marijuana. Well, that's, to me, that's a very questionable stop, right? I mean, how did you smell? How would you driving down the road smelling marijuana? Unless it's billowing out of the car, it's a pretty suspect reason to stop somebody. But in a judge, a General Sessions judge is put in a very difficult position if they're going to have to assess the credibility of the police officer they see every week or the person who just got arrested over the weekend. So, and an assistant district attorney, even a well-intentioned one, is going to have to buck the system and say, I don't trust that officer's judgment, or I think that there was a ulterior motive to why they wanted to get this person into custody, or, you know, because again, many of these problems start with best interest in mind. Maybe the young officer thought he was going to get a bigger drug bust when he pulled the person over. Maybe he thought he was profiling and he was going to try to clean up that neighborhood. But in reality, what he's done is he's arrested somebody on either no probable cause or such little probable cause that it should not be a lawful arrest. But then that gets passed on to the assistant district attorney. And how candid is that person going to be, meaning the arresting officer, to the assistant district attorney? Then the defendant, who just met his public defender, if he hasn't hired a lawyer, has about 5 or 10 minutes to try to get across that public defender. It's like, we weren't smoking anything, and that small amount of weed that was in the bag has been in there for a week. You know, we should be able to make bond because we really weren't doing anything wrong other than driving late at night and we got pulled over. So all of that gets compressed into that initial situation at Monday morning at 8:30 times about 70. There'll be about 70 of those cases on each one of those dockets. So you can see where, and I tell this to my clients, my initial goal in a case is to slow it down enough on Monday morning so the DA sees you as a person and not a docket number on the outside of the case. And so if you're looking for like, where does, in reality, where does the system first separate from a person's rights? It's during that first 15 minutes, because people are having to make judgments of credibility and judgments about things. And it's so ingrained in their weekly routine that many prosecutors don't even realize they're doing it. It's certainly not out of any malevolence. It's out of, and that gets back to the whole plea bargain cycle. It's out of wanting to move that docket through the system. And that's happening. You can come down, Troy, you can be my guest. I'll take you down Monday morning and we'll go into sessions court and you can watch it happening in real time.
Wow. Yeah, I would like to do that. That'd be great. So you mentioned, and both of you can speak to this. Go ahead.
No, Troy, I was just going to add, I don't think anyone on this call, I don't think this is news to anyone who's taken an interest in criminal justice reform. But, and I'm sure Lee has had this experience too. When you get these cases and somebody's been arrested and had no idea they were going to be arrested, maybe they were just driving down the road and they ran over the yellow line in the middle and got pulled over. And then there was something in their car that they end up getting arrested on. But oftentimes these arrests don't happen with people knowing they're about to go spend the weekend away from their family. So when we often meet with clients, there's a level of, as you can imagine, you are living your life in one moment, and the next you are being arrested and put in jail. Your kids, your family, your job, your pets, all of those things, you don't have time to make arrangements. You have been arrested. So, having an opportunity, as I'm sure y'all know, to make a bond or be released if it's a nonviolent offense is really, really critical, because I have had clients who want to plead guilty simply because they have obligations. They have a life to get back to, and these are minor offenses. And that's really, really disheartening.
So talk to us about the plea deals. The prosecutor, from what Lee says, they're trying to move the docket along, not because they have some ill intent, but it just becomes routine after a while. Then you have, Jessica, you said we have these citizens whose lives have been disrupted for some minor offense. And so in comes a plea bargain. Talk to us about that. How does that work? What kind of power does this prosecutor have?
Lee, I'll let you go ahead and start.
Okay. All right. Yeah. Well, plea bargains do resolve 95% of the cases in Tennessee. But I think you also have to remember there's evidence involved. So as a defense attorney, one of the first things you have to do is evaluate the evidence. And oftentimes, one of the reasons you enter into a plea bargain is because there is overwhelming evidence of guilt. And you can work the case out to a lesser charge than if you go to trial. Now, our office, we've tried 3 jury trials since the first of the year, this year. And I've tried over 200 jury trials in my career. These are felony jury trials, not counting misdemeanors. So our office, we do a lot of jury trials, but if we've tried 200, that means we've probably pled out 10,000 over the years. And what I'm getting at in the plea bargain is control is a really important part of the system. So if I'm representing somebody, let's say it's a serious case, it's a homicide case, and someone's charged with first-degree murder, and you have control of the case as you're working out what the plea bargain may be. And if the evidence supports what you think may be a jury verdict, and you can work the case out to a plea bargain to something like voluntary manslaughter, which in Tennessee, as a range 1 offender, is 3 to 6 years. And if that person gets convicted of first-degree murder, they're not going to see the parole board for 51 years. You've got to weigh out the evidence and the risk. Anytime that you release that control to a jury, to a judge in sentencing, you're focusing, or you're taking away the control for the client, and there's a substantial risk of conviction. So plea bargaining can be a very good thing if the client is realistic about what the evidence is, if the defense attorney is hardworking and understands and does his preparation, and you prepare a case for trial so you can take advantage of a plea bargain if you get one and it's the person's best interest. Where it breaks down is either if the evidence is not properly understood by the defendant, or if the attorney is overworked and is not looking at and evaluating it, or, and this is a rare case, relatively rare, if the prosecution hasn't turned over all the exculpatory information. So any one of those factors can lead to one of the cases that ends up in Jessica's office, somebody who's wrongfully convicted. But when each of those three components are done right, when there's full compliance with Brady under a prosecution's obligation in discovery, where a defense attorney has met his obligation to investigate and defend and properly defend his client, a plea bargain can be a good thing. But when it's the churning thing and the thoughtless thing, that's where it becomes a real problem.
Jessica?
Yeah, no, I agree with exactly what Lee said. And I think he raises a really good point. In Tennessee, a life sentence is 60 years. And that means someone will not see the parole board, as he said, for 51 years. So if you are facing a murder case, it puts you have to really, this in some ways boils down to how risk averse is someone. Like, I tend to be a very risk averse person on a personal level. So I don't like taking risk. And you could be innocent, but if the possible consequences are 60 years in prison and you may never see the light of day, you may be innocent, but at that time and at that moment, based on the evidence that's in front of you, you may say a voluntary manslaughter, that's in my best interest. And so people do plead guilty even when they're innocent because the risk is just too high. And as we set sentences, as if the legislature sets a sentence with a very, high punishment, that may encourage people to plead guilty because of the risk. Everyone in the courtroom has to be actively involved to prevent that from happening. The other thing that happens for us that we simply find out, which doesn't have much to do with pleas, but it can happen, is that the science just gets better or we get more information that we didn't have. The practice of law, in many ways, I compare it to automobile safety. So back in the 80s, we were all cruising around without seatbelts. Nobody had airbags. We were just hoping for the best, and people might, put their kids in the front seat and we were all just cruising along. I haven't practiced as long as Lee, so he may have a different opinion on this, but as we've gone on, we've gotten, I think, better and smarter and understanding what people really need to have a full and fair defense and what the options are for them. So we've added airbags. We know that we need people to be well trained. It used to be that if you were a defendant in a capital case, you might not have qualified attorneys. Now there's special rules that you would have to have qualified attorneys with a certain level of training. So all of that to say, people do plead guilty for a wide variety of reasons that often has to do with these resources that are available within our system. And one of the factors is definitely prosecutors, but there are many other factors as well.
Right. So, okay, you made a point. You said that you said the prosecutor gets to set the charges. So for whatever offense it is, whether it's a misdemeanor or a violent crime, the prosecutor gets to determine whether they're going to do the maximum or go to the extent of the law or something lesser. And then I guess what you said, I'm not guessing, you said also, so what happens is they may set high charges in order to get a plea. And so therefore the person still gets punished and the trial doesn't have to take place. How common is it to be excessive in setting charges? This prosecutor sets excessive charges because the law allows it in order to get somebody to plead guilty. And adding to that, how does that work politically in favor of or does it work in favor of the prosecutor politically as well to have a high number of convictions?
Jessica, go ahead.
So I'll be honest with you, Troy, this question's a little bit outside of the realm of what I'm doing right now. So I can only provide you one anecdotal example from when I was practicing. And that's in Nashville. Our district attorney, if he has, I'm unaware of it, he stopped charging as a drug-free school zone. That's the best kind of example I can give you on this. So I don't know if y'all are aware, but the drug-free school zone, depending if you were within 500 or 1,000 feet of a school, anything resembling a school, you would have an enhanced sentence. And it was routinely used in Nashville. Basically every interstate is in a drug-free school zone. So you could be driving through, going from Florida to Kentucky at 3 p.m. 3 a.m. in July, and you could be charged if you got pulled over and you had something in the car, you could be charged with driving within a drug-free school zone. Now, like maybe you never stopped in Tennessee. Maybe you were just literally driving through. So I think to me, that's the best anecdote I could give you of what that sort of looks like with the ability to charge. And so in the Nashville, I think it was across the board, but the district attorney was very selective in what cases. It used to be if you were stopped on the interstate in that sort of scenario, or you were driving by a school with drugs and the school was closed, say the school is under renovation, that would still qualify under the statute. But the district attorney, you know, when he came in, he made the decisions to be more selective. So to me, that is an anecdote of how a prosecutor could choose to charge different cases. And I'm sure Lee has some more applicable examples for Chattanooga.
Yeah, sure. And it changes geographically. So Hamilton County, we're in a judicial district, and these are constitutional offices, which means that DA is elected. It's in the Tennessee Constitution for 8 years. Just north of us, there's a different judicial district, and to the west of us, there's another one. So these offices have very different policies. Like up in Bradley County, they have historically overcharged in cases in order, in my opinion, to extract pleas. Whereas Hamilton County, not so much. I think that in Hamilton County, where the same problem occurs, but in a different way. So I don't see the overcharging of, or like, let's say the death penalty. I don't see the death penalty getting filed routinely in murder cases just to extract a conviction for life in prison. But I think, and you touched on this, Troy, earlier, the prosecutor, when he, let's say, used an example of a murder case, let's say there's a tragedy. There's one recently in the news where two brothers were drinking, a gun went off, one of the brothers gets killed by the other brother. Mm-hmm. That's currently charged as a criminal homicide investigation. That could come out anywhere from first-degree murder to criminally negligent homicide. Criminally negligent homicide is an E felony, carries 1 year, presumptions, alternative sentencing, probation. First-degree murder, we've already covered that. It's a very long time in prison. The assistant district attorney handling that case, or the elected DA, they have the sole discretion as to how to charge that case and what to accept in the way of a plea. Right. Judges do not have any control over setting what the plea should be or setting what the charge is. So even if a prosecutor isn't doing it so outrageously overcharging that it draws, newspaper articles and that kind of thing, if in the office they have that kind of power, it takes a very good attorney to figure out what is the difference between an accidental killing that might be negligence versus an intentional killing that might be homicide. Those are incredibly important decisions. And so in our example, that young person, if it's an accident, he's going to be, if he's charged with murder, he's going to probably be in custody through the entire case. If he's properly charged as criminally negligent homicide, reasonable people could argue about whether it's a crime or not. He's going to be out on bond, and then he can be with his family, and then his experience in the whole criminal justice system is going to be different. The only people who make those decisions are the assistant district attorneys in the office, and it's not uniform. Some are better than others. If you take an office that has 25 assistant DAs, you may have half a dozen that are really good and do their job and take this seriously and can get to the bottom of it. And you may have a half a dozen who don't. And if you're practicing law as a public defender or a private lawyer, you understand quickly who those people are, where they fall on that, and you have to explain that to your clients. Then, of course, there's the whole perspective of the defendant. You take my example, if that's an accidental shooting that happens in a housing project versus an accidental shooting that happens up on Signal Mountain, the perceptions of how law enforcement greet that accident, the perceptions how the court and how the prosecutors, and a lot of this stuff, it's not intentional. It's just who these people are and what their socioeconomic background is. And then justice becomes very uneven that you see and how it's dispensed and how it's experienced if the same resources are not expended in those two cases. If that makes it clear.
Right. Yeah, it makes it clear. You said that there's sole discretionary power that lies with the DA or the prosecutor. So what you're saying is the police officer can't say, hey, charge. He can say it, but he can't. He has no legal grounds to charge. The judge
After
has,
arrest.
after arrest. Right.
So once the arrest happens, so the way you break it down real simple is whenever the conduct happens up to the point of arrest, that's the officer's discretion.
Mhm.
From the arrest, once it gets down to the courthouse until the end of the case, to charge, to dismiss, to reduce, to enhance, sole discretion is in the prosecutor's hands.
And
The judge can accept or reject a plea. The judge cannot change it, cannot change the terms, cannot change the charges.
Wow. And so I know this is an obvious question. How does that work as far as demographics are concerned? What have you guys seen? It's fair across the board. The DA treats everybody the same, I'm sure, and you guys have seen these DAs deal fairly with every person, no matter what ethnicity, male, female, or whatever. Is that right?
Absolutely. Yeah. No, I mean, I think which in your question, that's probably getting at before, is the obvious cases where if you have a prosecutor the system can deal with that. If you have a prosecutor who's intentionally doing something against somebody because of their race, their gender, their orientation, well, you can respond to that. What's insidious about it is if you're somebody from an impoverished background and there's high crime already in your neighborhood, it's going to be over policed to start with. So if you're smoking marijuana with your friends on the corner, you're already going to be under more suspicion than if you're doing the same thing behind a middle school in another part of the county. And so when you come into the system, the rough-handed nature of it, or the uneven nature of the justice system, is there are so many perceptions that come with the people as they come into the system.
Mm-hmm.
And so who your lawyer is, what kind of lawyer you have, what the background of the officer is when he's making contact with you, the actual circumstances of the arrest become critically important. We had I think it was a DoorDash driver delivering African-American DoorDash driver delivering a meal out in Collegedale night before last. Officer pulls him over. Young man has no idea why he's being pulled over. Gets tased. He's doing DoorDash. He gets tased. The district attorney just announced today he's asking the sheriff's department to investigate that officer. So that's good.
Wow.
So that's good. But that's what I mean by that's an obvious example. You take 3 young African-American men who have a small amount of weed on the corner, and they get pushed up against the wall, frisked, and then they find a handgun on one, and then they put them all in on Friday, and they're going to spend all weekend in jail, and they come out Monday morning into sessions court, and all 3 of them are charged for some small violation. You're never going to read about that. You're never going to hear about that. But they may take that simple misdemeanor plea, 1129, suspended on good behavior, because you get out of jail. It's just a misdemeanor on your record, so it seems like it's not a big deal, but it's a conviction. I have young men come into my office all the time and say, hey, how do I get this off my record? I've been offered a job and they're going to do a background check. And I'm like, you pled guilty 3 years ago. It doesn't come off your record. And so, and then on the public defender side of things, they're well-intentioned, but they have huge caseloads. And then they have a young man in custody and they may say, well, if we can reset this and have a hearing, we can get this dismissed. And the person's like, I don't reset it. I want out. It's Monday. I've been in here since Friday. I'm going to lose my job if I'm not there tomorrow morning. And so that's where people get ground up, meaning literally their lives ground up, because the system, it's a very blunt instrument. And then, of course, the worst examples of that end up in Jessica's office.
Right. And so what I hear you say, what you guys are explaining is the DA is almost like the queen on the chessboard, has the most power, but the whole system is a system that probably needs an overhaul in some way, shape, or form. I was listening to you, Lee. You were explaining, and you talked about the amount of assistant district attorneys and to the caseload. And so for both of you, Jessica, I'm thinking about you in particular as you deal with these folk who are innocent and trying to get them cleared. Do you find it frustrating, or can it be frustrating, to deal with a district attorney's office that's understaffed and underfunded? And not only frustrating, how hard is it to actually get some legitimate business done when you have these offices that don't have, not just routine, let's just get them, but not cycling through, to actually look at a case, pay attention to it, and give it the attention it deserves? How difficult is that if an office is understaffed?
It's nearly impossible. And the name of the game is resources. Everyone has to have resources. So, we have an incredible public defender's office in Nashville, but I'm sure they would tell you that they have too many cases. As we over-criminalize or continue to criminalize everything in the book, we're going to have a greater volume of cases with a greater number of people. Like you have to make some changes if you want to decrease the volume that the system is currently experiencing. And, I think it's very common for public defender's offices to receive a fraction of the funding that district attorney offices receive. So for us, in Nashville, we have what's called a conviction review unit, and we are really hoping that we see more of these across the state. Conviction review units, conviction integrity units, it's a unit within the district attorney's office that is independent, and they take a look at their cases and they determine if a mistake was made. Now, obviously, most of these are looking at longer sentence cases, not the everyday misdemeanor case, which is, I think, mostly what we're talking about when we talk about the system sort of being like this meat grinder that just brings people in. But for Nashville, the conviction review unit, they have attorneys who are trained and designated to work on these cases, because the reality is this: if you have 12 cases set for trial in a year, if you're a prosecutor, you've got 12 people pre-trial. These are serious cases. You're going to be navigating dozens of witnesses. How do you expect a prosecutor in that position to then go back, and even if we do every bit of investigation, even if Tennessee Innocence Project brings a book of materials that says you should overturn this conviction, here's 12 reasons why, documented in hundreds of pages, how many prosecutors really have the option to sit at their office and look at something like that and evaluate it? So we really want to see more conviction review units in place across the state, because it's made such a tremendous impact on our work and really allows us to be more expedient. We're not arguing over, should we do testing? We reach agreements to get documents, to get files, and see what the truth of the matter is. It's one of the few areas that's collaborative in many ways within this current system.
Wow. Yeah, it's hard for me not to get frustrated over this.
But I think, the tone of the elected DA is often felt throughout the entire office. So if you have an elected DA who wants to make changes, who wants to acknowledge the impact that sitting in jail can have on people, that brings life experience with them, that, shows a wide range of experiences and has maybe worked on both sides of the bar, I think that's really important. Elected DAs do set the tone for their offices in what is sort of expected, even though the ADAs have a lot of discretion. And I don't know if that's the case in Hamilton County, but that's been my experience in different jurisdictions, is your elected DA really does set the tone of what's expected.
Lee, you want to share?
Yeah, that's true, and that's been true in this county for a long time. Troy, back to your point about the frustration, I think, and this is really good, important for your group to know, the DA is elected every 8 years. The sheriff is elected every 4, and the county commission and the county executive every 4. If everybody on this call and everybody who thinks this is an important issue, they reach out to their elected representatives, whether it's a city council member, because the mayor is elected every 4 years, and the city council as well. But you reach out to the mayor, you reach out to the city council, you reach out to the county executive and your county commission members. Issues of mass incarceration were not discussed at all 20 years ago. Every elected official is aware of it. They just may not be aware of the impact in their local community. And so if you're looking for something to get behind, definitely the DA's race is really important, but these other races are too, because they're the purse strings behind the DA's office and with your legislature behind law enforcement. And if that becomes a priority, you can move the needle by people getting active. Apathy and not voting are the worst things. That's the worst things that can happen. Activating people and letting your local elected officials know that this is an issue important to you and it's something that you vote on, that will get their attention. And if enough people do it over time, that's where change happens. Change is hard, change is slow, but it happens.
Okay. Boom, I have like 10 questions, but I'll stick with the first one that came to mind. And Jessica, you mentioned a DA that can have influence, and that goes along with Lee saying vote somebody in that has influence. In Chicago, they elected, I can't remember the lady's name, but they elected a Black district attorney who had the two sides experience. She worked in the public defender's office, and she also, I believe she did some criminal stuff as well, but she ended up running for DA and she got elected. And so she did some of the stuff you talked about where she reduced some of the things they were going to charge. They stopped, instead of $500 for a theft, I think they raised the bar to $1,000 or something like that. And then they were able to clear up the clutter of cases and begin to prosecute some of the more tougher cases, so forth, so on. She was real progressive. What is the danger? Well, let me say it this way. What is the danger of a conservative DA or a progressive DA? Talk to us about the nature and personality of a DA, dangers and otherwise, and benefits, and how that influences criminal justice reform in Hamilton County in particular, but in general as well.
My answer, I think, is pretty narrow as to that question, which is really related to conviction review units and a willingness to investigate if the office has made mistakes. This whole system is built on human beings. And so we really emphasize that people could be wrongfully convicted or kind of swallowed up by the system, not because anybody did anything intentionally, but just because there's been a change in science. We now know more than we used to. We can do DNA testing we weren't able to. And so for us, when you talk about progressive district attorneys, you know, I think Larry Krasner is probably the most well-known, and it's about a willingness to evaluate the work of the office in the convictions that have taken place. And then I think a truly progressive district attorney will not only fix those individual errors that may have been made, but then they're also going to ask, how can we take this information that we've learned and make sure we prevent future wrongful convictions? How can we make the system better? My answer to that is pretty narrow as it applies to the work that we do. Are you willing to explore wrongful convictions or the possibility of a wrongful conviction? It could also be that, we all agree to do testing in a case, whether it's fingerprint or DNA, and it could come back and prove that the person's guilty and that the system got it right. To me, it's about a willingness to engage in that process and really explore if this was a mistake in the system.
So before you chime in, Lee, real quick.
Yeah.
So with you guys, Jessica, you guys handle Purvis Payne, is that correct? Did your office deal with him?
We are not on that case, not for any particular reason other than Innocence Project New York is on that case. And then there are other people in Tennessee involved. But that kind of was all taking place when we were just launching as an in-state organization.
Okay, I was going to ask a follow-up, but don't worry about it. Lee.
Well, I think here in Hamilton County, especially as we have a DA's race happening here, things people have to watch for is, what is this is back to your question about conservative DA versus progressive. What is the DA's message? A DA needs to be independent of the police. The DA needs to evaluate cases on their merits. And if a candidate is out there, and this gets to the conservative thing, if they're trying to out there saying, I'm a friend of the police, or I am the police, or I've got your back as the police, that is not the DA's role. And when I was a prosecutor, some of the hardest cases I had to deal with was telling an officer when they violated somebody's constitutional rights, or when I prosecuted an officer, as I did, you got to be at arm's length from the police. you have a relationship where you prosecute cases, but when a political candidate is running their race as I am a friend of law enforcement, or I've got your back, that is a huge problem. But how is that person in any way, once they have this office for 8 years, going to be able to protect the public? They've already created a bias within that office, and it's a recipe for disaster. We are unfortunately in a time right now where the city of Chattanooga is progressive, the county is not, and we are fairly lopsided in terms of the political realities of that. So that's where, when you can vote for people who may not be the district attorney but have input in the system, elect those people who reflect your values. The current DA has decriminalized small amounts of marijuana because he has recognized the problems that have happened across the state. Glenn Funk in Nashville led with a lot of these things, somebody who had a previous defense attorney perspective. That's helped in other states. There's a district attorney's conference. They learn what other people are in other jurisdictions. So in Hamilton County, we now are not prosecuting small amounts of marijuana, whereas 6 or 7 years ago they were. But I think for everybody who's participating in the Zoom call, be critical. All three of the candidates who are running out there for district attorney have flaws to them. There's nobody who's not a flawed individual, and I imagine that's true for every race. But in this race particularly, on the Republican side, both sides have issues. But look at the ones who seem to have the office at arm's length. And I think that's probably the thing you have to keep in mind. Back to your question about conservative.
Thank you. We got like 10 minutes left, so I want to inject something. Well, let me just. There's a podcast. This is for everybody listening. There's a podcast. If you haven't heard it, it's called Justice in America. It's an excellent podcast. They have about 30 episodes or so, and it just goes through justice in America, justice system in America. I recommend it to everyone. In a podcast that talks about the role of the prosecutor, one of the points they made, and I want you to expand on this. They said there's an equation in every prosecutor's office across America. That equation is power, accountability, and incentives. The prosecutor has lots of power, they say. They have little accountability, and they have incentives both ways. Incentives to get a lot of convictions because they'll keep getting elected. And they'll have no incentives to hold police accountable. Do you agree with that? Do you disagree with that? Why or why not? Power, lots of power, little accountability.
You mean
incentives?
I'll hop in on that. Absolutely true on the power. Absolutely true on the little accountability. Prosecutors, I mean, I think if you ask most people, if you went out on the street and asked people who the prosecutors are, they'd have no idea. A friend of mine ran for public defender 8 years ago, and he was going door to door. And the average person thinks the public defender, think of what the name sounds like, defend the public, was the prosecutor. He had to educate voters that, no, I'm on the other side from the prosecutor. So that gets back to the no accountability. I think it's largely been an invisible position over time. That's changing. That's definitely changing. I think that with the accountability about the police, that's also changing with technology. Cell phones and body cams have made that, I've been practicing law 35 years. Cell phones and body cams in the last 10 to 15 years have completely changed that. Good ethical prosecutors, like the news story that broke today about on the Collegedale officer who tased the young food driver. Good ethical prosecutors follow the evidence. And so when there's a citizen cell phone or a body cam on an officer and it shows a violation, they follow that. We've been talking all about state court, and we've been talking about state court prosecutors. There's a whole nother level. There's the federal side, federal prosecution, and there are civil rights divisions, both locally and at a main justice in DC. Those organizations will get involved. I mean, the federal prosecutors will get involved if they see a system of civil rights violation in a local police or local district attorney's office. Now, it's got to be an order of magnitude, but those things are out there. And I think that having public integrity sections out of main justice in DC helps. And really, it's having citizens who speak up and act out when they see this stuff happening in their communities. We are in a different justice system than the one I entered when I was a young attorney, and it's a better one. Now, there's still plenty of problems, but 25 years ago, there was no accountability. Now there is some accountability. And I'm not going to tell you that we're even close to where we need to be, but we're at least having those conversations, even in communities like Chattanooga. Those conversations are happening. They're happening in city council meetings, they're happening in county commission meetings, and they're happening within the district attorney's office. And the makeup of the district attorney's office is now more diverse than it was 10 or 15 years ago. And that's probably, if you want to get to like, how can you put pressure on the elected DA, put pressure on them to hire more young assistant district attorneys that reflect the community around them.
Outstanding. Jessica.
Again, I have to agree with everything Lee just said. You know, I think the other thing I would add is that the system is changing in part because we now know that innocent people get wrongfully convicted. And so why do they get convicted? They get convicted because we know that sometimes witnesses lie. We know that sometimes police withhold evidence. We know that sometimes prosecutors withhold evidence. We know that defense attorneys don't always do the best job. We know that sometimes defendants falsely confess to crimes they didn't commit. So again, this goes back to my analogy about automobile safety. I think as we're getting smarter, as we have good empirical data to support these changes, we're going to see more of a willingness to acknowledge the system has not always gotten it right. I think there's even been a change. I've been practicing since 2011, and I think there's even been a change since then. And I think we're headed in the right direction. But back to Lee's point a few minutes ago, I've had, local or state legislative officials say, we don't get that many calls on stuff. When you do reach out and call your local, commissioner or representative or state senator, that can be very meaningful because you're reaching out to them about something that maybe they're not aware of. Maybe it's not on their radar. And you have the opportunity to create a relationship with them where potentially, they can get to know you and, seek your guidance in the future. So I think that's a really important part of working with local governments and state government that we are just now learning. There is more power to that than you might, initially think.
Right. Right. Oh, we have like 4 minutes left. So what I'm going to do, I'll give each one of you about a minute or so to give us some final thoughts as it relates to the prosecutor. Thoughts, warnings, cautions, however you want to present it. Jessica, you go first.
So, I think prosecutors set the tone for their office. And I think hiring diverse people with a wide variety of life experiences is really important to creating understanding of how our clients sometimes end up in these positions, whether they're guilty or innocent. For us, working with clients who are asserting their actual innocence, it's an open-mindedness to exploring whether there could have been mistakes made in the past, because this is a system comprised of humans. Jurors are humans and they only know what they hear in the courtroom. So, a willingness to reflect on the work that's being done is really important. I think we've hit on a number of topics tonight that when you hear your district attorney candidates talk, whenever you maybe go to your next, you watch the next commissioners meeting, these are all topics that you can begin to have a conversation on. And I think there's a lot of room for improvement in Tennessee. And it's really exciting to be on this call with y'all tonight, kind of exploring some of these issues.
Okay, thank you. Lee.
Yeah, I think that the best thing that I guess that I would finish on is that we don't vilify the individual. So people who are running for district attorney, they're running for a reason to help and better their community. And if we turn it into a us versus them thing, then there's no chance for communication. So if we approach it from saying the people who are running for district attorney, from their life experience, they're coming at this from what they believe to be in the best interest of their community. How you can I think further the communication, further conversation is help point out to them that they may not be aware of things happening right in front of them. The example, and Troy, we talked about this the other day discussing this panel, is assistant district attorneys are often hired straight out of law school, no experience. They have very little training about what they're doing. So let's assume they went to a UT law school, they get hired by the Hamilton County District Attorney's Office. They're happy to have a job. They're doing important stuff. It seems like there's a lot of bad people that's coming into this community that they prosecute. They're meeting with victims, and the victims are thanking them for what's happened on that individual case. They can become desensitized very quickly. And so if groups like yours reach out to assistant district attorneys and get an assistant district attorney to participate in your programs, other similarly aligned groups reach out to assistant DAs and say, we want your input. We want to hear what you know. I've watched drug courts grow up around the state, and mental health courts and veterans courts. And when assistant DAs become involved in the drug courts and the mental health courts, and they start connecting with these people, they become strong advocates for these issues. And if those assistant DAs, just like the elected DA sets the tone up top, the assistant DAs across the bottom, because they're the ones who serve on these committees on something like drug court, they take those experiences back to their bosses, and they're making relationships with the other private attorneys and public defenders that they serve on these committees. And then they have common ground on those issues. And then that can lead to either political solutions or longer term improvement of the justice system. So it comes down to relationships. It comes down to people realizing, don't vilify each other, but there's something we can all learn from each other. And no matter how much you think you may disagree with that prosecutor, talk to them. Sit down and talk to them and get them to come to you, because most of them are good people. There always are a few that are bad, right? And you can single those out. Ask the court officers; they always know. And so once you figure out who is the right person to approach, build on those relationships, and that will bring positive experiences back to your group.
Awesome. I want to thank both of you for joining us. I think we had an insightful conversation. I know that I have been enriched from your experiences, and I'm sure everybody else has too. I'm not sure, Alan, if we're going to have some contact information, if people on the panel want to reach out to you and maybe ask you guys and ask some questions later on. I don't know if you guys have that available, but we make that available. I don't know.
Sure.
That'd be great. You guys did excellent. We really appreciate you and look forward to hearing from you again. And this relationship that we formed between you guys and Caleb, may it be a lasting relationship. We're going to bring Pastor Mike back on, and he's going to do what he does.
And here's what I'm going to do. First of all, I'll add my thank you to that of Troy's, to Mr. Davis and Miss Van Dyke. Really, really appreciate you all being here and sharing. Really, really good stuff. We do want to do one thing. I want to do one thing before I turn it back over to Alan to wrap us up. I want to give folks an opportunity to be able to financially support the Tennessee Innocence Project and Miss Van Dyke's work and the work of her staff there. As we discovered, or were reminded again tonight, for those, when we don't get it right the first time, let's see if we can't get it right the second time. But as Miss Van Dyke's website notes, and as she's noted, that takes a lot of human resource hours and energy to make that happen. And so we are putting a link in the chat. If you would like to click on that link, you can make a donation to the Tennessee Innocence Project and help provide further resources financially that can enable greater human resource to go to work for those who have been wrongfully convicted. So you'll find that link in the chat. Encourage you to go there if you would like to. And at this point, Alan, I think I will turn it back over to you.
Thank you all. Thank you to our guests. Thank you, Pastor Troy, Pastor Mike, for being a moderator and a host tonight. I guess what I would like to wrap it up with, definitely chiming into why this is important to us as the Criminal Justice Task Force. One, it ties into our values that we have held upon within the Criminal Justice Task Force. We have 3 core values that we agreed upon as a task force, and I'm going to announce those. The first one is liberty. It's the norm pending the pre-trial. The second one is justice for all without profit or excessive fees. And the third one is incarceration is the answer to mass incarceration. And what we asking for out of those things that we're core values that we're setting is build release without restriction. So basically have pre-trial support rather than supervision. Next, reducing time in custody. And also to collect better data and better pre-trial data here locally for the Hamilton County, our county itself. That reduced time in custody ties a lot into our Hamilton County Community Bail Fund. That plays a big part into why we created the Hamilton County Community Bail Fund. The pre-trial part where a person is innocent until proven guilty, where a person hasn't seen a judge, but they actually are still incarcerated because they cannot afford to be able to bail out. So that's why we have the Hamilton County Community Bail Fund, because it brings value and it actually helps a person that cannot help themselves in that situation, an unfortunate situation that they're dealing with. Also, too, ways that you can help us out to be able to move forward and get the word out on these things and the different ways to move forward without justice series. One in particular, and we're going to share it. We're going to ask for you to share the Vera County fact sheet. We put this into the chat. This is actually on our website. Vera is a partner of ours that we work with, and we're going to actually have an upcoming event also here coming up in April with Vera. This event will be on April the 28th. Actually, it's going to be at the Camp House. Thank you for that. So this event is coming up April 28th at the Camp House. We're going to be actually chiming into public safety and public harm. This is a partner event with Vera, and at this event, we're going to have some special guests for you all. Hopefully, this event is going to have a good turnout, but we would love to see you all there. That's one way to support us. Also, too, Vera event, whether the sign up for the Vera event, but also, too, we're going to be having upcoming justice series forums. So the DA forums, commissioners, different forums like that upcoming and during the summer that we would definitely love for you all to come out to and help support and get the word out for to keep this motivation going. And there's a way to get involved. I guess I would end personally from a personal experience, since I'm a formerly incarcerated male, and this is something I've definitely wanted to think about how I wanted to push out. And I love that our presenters had actually spoke in on this. But one thing I would definitely want to say to you all is that we don't want to be able to, such as myself, I had a case that I ended up being innocent on, and that case lingered on for over a year, maybe a year and a half. And I can tell you during that case, I lost a lot. Place, cars, you name it, I lost a lot throughout that year and a half where I could not be employed or anything. But I can say through organizations like Caleb and other organizations here locally, I have seen there's a way out. Just because a person's formerly incarcerated doesn't determine their capabilities in their future or anything like that. So we all have the opportunity here today with the things that I brought up and the things that we talked about to help support. We would love for you all to come along with Caleb to be a part of this work that we're doing in the criminal legal system. We definitely want to, see something go right here locally, but we definitely want to see it go right with the right people leading it. And I definitely feel like people power and us coming together collectively will definitely make a change and a difference into what we're trying to do here in Hamilton County. And not just in Hamilton County, statewide. We definitely want to chime into that. We have partner sister organizations all throughout the state. We have Noah out of Nashville, and we have Micah out of Memphis that we definitely support, that we want to plan to go moving forward doing statewide things outside of the local things that we're doing here for us with Caleb. We thank you all for your time here tonight. I see we're ending a tad bit early. So I guess if we don't have any chime in questions or anything lingering right now. It's not. But thank you all. Have a good night.
Thank
Good night.
you. Take care.
Thank you, everyone.